Hi, everybody. Good morning. My name is Steve Blake, and I'm here with Bob Flynn today, and we're going to talk to you about strategies to find success in mediation. And my name is Steve Blake. Like I said, I'm an attorney in Southern California, and I handle a lot of real estate litigation and disputes and a lot of mediations involving real estate disputes, business disputes, and things of that nature. So I've been to a lot of mediations, and I'll let Bob introduce himself here. If you want to go ahead, Bob.
Steve, hi, how are you?
Great.
Yeah, great. Yeah, thank you for the opportunity to be with your clients and friends, so to speak, on this podcast. This is my 50th year practicing law. I practiced in Boston. I moved here about 10 years ago. My legal work is confined actually in California to doing mediations and arbitrations as a mediator and an arbitrator, a neutral. Um, and my legal work was largely as a trial lawyer. So that's Bob.
Great. Yeah, and so we hope to give you guys some good tips on mediations today, coming from an attorney who represents clients in mediation, and then also Bob, who has represented a lot of clients in mediations, but also acts as a mediator, mediating cases. So first of all, what is mediation and what isn't it? And, there's a lot of confusion with people regarding mediation that have not been involved in the process before. So Bob, do you want to talk a little bit about, why parties should mediate?
Yeah, so mediation itself is the voluntary but facilitated negotiation of the resolution of a dispute. That's really and truly what it is. In other words, people are getting together in one place at one time, focused only on that case. And the focus is achieving a resolution, a settlement. It's in contrast to trying a case before a jury or a judge, or arbitrating a case where somebody, a third party, makes a decision. And why mediate? Well, it works. It really does. It works. And by working, it saves time, saves money, saves emotional capital, and it saves the enormous anxiety and worry that people have throughout litigation. So that to me is why mediation.
Mm-hmm. And the key point is it's a voluntary process. Nobody can force you to mediate, but typically, when to do a mediation. A lot of times parties will do a mediation if there's a threat of a lawsuit that could happen. One of the things the parties can do is agree, prior to filing this lawsuit, let's see if we can mediate it, sit down in a room together and get it resolved. And if they can't, then, the parties can file all the lawsuits they want. Oftentimes too, parties will have mediations while a lawsuit is pending. After the lawsuit's been filed, there's nothing prohibiting the parties from mediating at that time. One of the nice benefits about mediation is it's confidential. So you're allowed, under the rules of law in California, you can go into a mediation and, say certain things, maybe things that aren't very favorable to your side of the case, but it's all confidential. It can't be used against you later in court if it ended up that way. The mediation is private. If you do come to an agreement with the other side, it's a private agreement between you. It's not going to be, published anywhere, or, it's not a court record. It's just a private agreement. Another benefit of mediation is it can maintain future relationships. So, you may have a dispute with a existing client that you get a lot of work from, and you don't want to file a lawsuit against that client because they're an important client to you. So, maybe you decided to go to a mediation and you can work things out. And then, the last thing that we already said is it's voluntary. There's no requirement to mediate, but even if you do, sometimes in mediations, if there's no deal to be reached, the parties can just walk away, and it's as though, they're back to where they started. If you do decide to go to mediation, there's certain things that you can do to prepare that can really help get the case resolved. And Bob, do you want to talk about this number one here, the lawyer's involvement?
The lawyer's involvement, sure. That goes back a little bit to timing and different cases, different claims, different disputes uh, can be thought of a little differently. I know you are involved in a lot of real estate matters. Real estate disputes, for example, residential real estate disputes, really the contracts require mediation. They can't really make you mediate, but there's a sanction if you decide not to. And the sanction is compelling. Maybe you could talk about it in a minute, but I do believe that real estate cases and personal injury cases and business disputes should be mediated as soon as possible. If it goes into litigation, as soon as possible, and possible is defined by all the lawyers getting very comfortable, familiar with their case, so they can properly mediate it and resolve it. But sooner is always better with mediation. Preparation, that brings you to day one of the lawyer's involvement. I think a lot of lawyers have made mistakes. I know I did early on in not really seeing what they were doing. The goal, always keep your mind on the goal. The goal of every claim, every dispute is to end up getting it resolved. Now, some people injured in an accident badly or who are seeking some help with a claim against a professional or a real estate dispute, they see their goal as like winning a huge number, but you have to figure out what your goal really is. And the big picture is resolving that dispute is the number one goal. Everybody's happier without a dispute. So
Yeah.
the lawyers should explain that on day one to their clients, that while you have a serious problem here, your goal isn't to set the jury box aflame with people jumping out and throwing money at you. It's just take care of your real needs and figure out what that is.
Yeah, and I consult with a lot of clients about mediation early on because going to court is a risk. And no matter how strong you think your case is, there's always a risk, and you never know what's going to happen. And it costs a lot of money to find out what that decision on that risk is, and it takes a lot of time. A typical court case can take 2 years before it gets to a trial. And mediation, if you can really work with your clients up front and talk to them about what's the ultimate objective here, what's the best case scenario, what's the worst case scenario, what would you be willing to live with today to get this resolved, and you kind of start helping prepare your client's mindset so they understand that mediation is a very meaningful and beneficial thing. And part of what we said in number 2 here is trying to discourage litigation. I'm a litigation attorney, so I handle a lot of litigation, but I always tell clients that this is going to be expensive, it's going to be emotionally exhausting, and it's going to be time consuming. So it's worth it to mediate, and it's helping prepare your client to get into that mindset is an important role as an attorney. And then even when someone like Bob steps in as the mediator, when he's actually handling the mediation, he's going to spend time with the clients, talking to them about the risks of litigating the case, and why it makes sense to try to get it resolved. So preparation is very important.
It is.
And then this next slide is talking about, like, let's say everybody's on board, we want to mediate the case. What's the next step? And one of the first step is obviously selecting a mediator, like who are we going to use? Making sure that the right parties are going to participate. You want to make sure everybody's there, because if somebody's not there that is key to getting the case settled, it's probably not going to settle. And then once you have your date selected for the mediation, it's typical that the parties will submit a mediation brief, which is typically, like a 5 to 10 page letter to the mediator explaining, your position, what the background facts of the dispute are. And Bob, do you want to talk a little bit about your experience with mediation briefs?
Yeah, I do. That's great. So one reason mediations are so successful in resolving disputes is that people have chosen a mediator. They've agreed on that. They've agreed to go to mediation and they've chosen a mediator. They've chosen a date and a time. So there's already been little mini micro agreements on the way there. The mediation brief is another good example. I will talk with both sides, usually separately, before a mediation begins. And I urge both parties to provide briefs that are brief, but cover what you need to cover, and recognize that I, as a mediator, am not the judge. Yeah, they're both the judges. The clients are going to be the dispute resolvers, but they have to let me in on what's going on. So real facts are really important, the outline of the case. And a lot of lawyers like to keep their filings close to the vest, like there's a super secret something. And I urge them, no, share what it is. Keep in mind, I'm not the target of whatever you're saying. The other lawyer is, the other insurance company is, the other client is, the other side is. And it should be written, whatever it is, with them in mind, understanding that they'd see it. If you have something confidential and I need to know, you want me to know it, give me a confidential 2-page, 1-page, 3-page thing in addition. But begin to sell your claim or your case or your issues to the other side with that mediation brief. And there's a key document or something. Lawyer's judgment is entirely critical there. Whatever they think I need to be helpful to them, they should let me have.
Yeah, I found the best success I've had with mediation briefs is keeping it short, keeping it concise. You don't typically need to go into long, lengthy arguments about the law and how it applies or doesn't apply. The mediator is not like a judge or an arbitrator where they're going to make a decision on who's right or wrong. That's not the mediator's role. The mediator is there as a neutral to help negotiate a resolution. So the mediator is going to pay attention to the facts and the law, but they don't need to receive a novel on what a statute means and how
I ask people, what would you like to receive, and that would get you into it and put you in a position to then hear and understand the opening arguments of lawyers.
Mm-hmm.
So that's
yeah, and Bob mentioned as well that a lot of times when he does mediations, in addition to the mediation brief that both sides submit, he's also going to have a phone call with each of the lawyers before the mediation takes place, so he can get an understanding, what are the trigger points, what are the hot button items, what are the items that the parties agree on, maybe we can check those off the list and not have to spend time with those on the day of the mediation. So it's important, good mediators like Bob, they're going to spend the time to understand those personalities and dynamics so that when you actually do get to the mediation, you're not spending a lot of time dealing with those type of things.
Yeah.
This is an important slide regarding just who is at the mediation. And when you're trying to get a case settled, it's important, that everybody's that needs to be there is there. And, sometimes it's just a two-party dispute, homeowner versus homeowner or whatever it is,
Right.
but sometimes there's insurance involved. And the insurance company is providing coverage to one of the parties. So we like to have that insurance adjuster either at the mediation or at least at a minimum available on telephone standby. So if we need to ask that insurance person for authority to pay a certain amount, we can get them on the phone, they can agree. We don't want to have to do something where, hey, we need to leave this mediation and contact the adjuster. We'll get back to you next week. Like, that's not acceptable. Sometimes we'll have expert witnesses that are available. Like if it's a really complicated, title issue or easement issue with the property and you need a surveyor to kind of explain, what they found at the property, that can help. And then Bob, do you want to talk about the joint sessions and what those are?
I do. That's a important thing from my perspective. I'm a big advocate of them. In fact, I didn't realize until about 10 years ago when I moved to California that they've become increasingly less valuable in the eyes of some lawyers in California. I think they're critical. And I'll explain why, but who attends, I mentioned a little earlier, the success rate is really so high on resolving disputes at mediation because everybody who has a vested interest in it is there, focused just on that case and exchanging information. And if somebody isn't there, if they're on telephone call, it's not the same. And it really isn't. So even if there is an insurance company, as an example, whose lawyer is present, the lawyer has a different way of seeing things than the insurance claims people. They need to be there. And then you want them there, I do, as a facilitator or a mediator. I have to pay that electric bill. I have it set so the light goes out. I'm very cheap. But the joint session is an opportunity for everybody to hear from me for the first time. Clients have almost never been there before, except professional, like insurance adjusters who are regularly doing things like that. And I like everybody to understand me on the same page as to what we're doing. It's a purely voluntary endeavor. And on the other hand, we're going to work. We're going to go through the case and we're going to look at the different parts of the case and challenge people to their assumptions. I ask each lawyer, as a follow-up to the brief they filed, to make an opening statement, but there's no jury there, so they don't have to go wild with exclamatory utterances. A lot of lawyers are reluctant to do the joint session because they keep saying, well, my client hates this person, or the other person hates my client, or there's an animosity. And my constant refrain about it is they'll never find a safer place in the entire world to hear the other side's presentation of the case, and they need to hear it. When you get to a courtroom and then you hear it for the first time, it's still hearing it, but it's not the most advantageous time to hear it for the first time. So I like everybody to make a clear, concise, like their briefs, opening statement, hitting the issues that are their strengths and what they think the other side's weaknesses are, being very polite. I'll explain that. And often urge people to. So we're going to go into caucuses in a moment. And is everybody ready to be realistic and reasonable? And people always say yes. And it's kind of hard mentally to back away from that later on.
Yeah, and just for the audience, in a typical mediation, when you get there, one side will be in a room by itself, and the other side will be in a different room by themselves, and the mediator will go back and forth throughout the day talking to the parties. And sometimes the parties themselves, they never see each other at all during the day of the mediation. And what the joint session is usually done at the beginning of the day, and it's something where the parties do see each other and everybody's in the
Joint
same
speak.
room. And, like Bob said, it's got to be respectful and polite, and it's a chance for both sides to kind of hear from the other side directly what their position is, why they think, they don't have any liability, or why they think they're owed X amount of money. And, the mediator's there controlling the room. So, if it gets emotional or gets out of hand, the parties can, go to their separate rooms. But I like joint sessions. You have to kind of gauge your client's emotions. They might not work for everybody, but for the most part, I think they're good. And a lot of times, the actual party to the dispute, like, it's a chance for them to be heard and to get off what's on their chest about the dispute. And I do think it helps. So it's something that some mediators might not even bring it up, but as a lawyer, it's something that I like to talk about with the mediator. Like, do you think it's a good idea to do a joint session, or do you not? And also throughout the day, there's times when the mediator might want to just talk to the lawyers by themselves. And so the mediator can come in and, bring just the lawyers in another room, and we can hash some things out. So it's a
Another
good option to have.
another real benefit to a joint session is the parties may have never seen each other. They may have an idea the other side is an ogre, or they may never have seen the lawyer on the other side and may think the other lawyer is driving a horrific bus of trouble for him. And getting to know each other is part of getting a case resolved. An insurance adjuster would really like to see a plaintiff and hear a plaintiff. I ask both sides, the parties themselves, but I've cleared it with their lawyers. Would you like to say a few words about how this has injured you, or what the failure of the real estate deal has done to your home search? Think some question, and then the other side too. So gets everybody engaged, and those are among some of the big benefits of getting together at the very beginning before going to caucus rooms, I think.
Yeah, and the last thing I'll say on attendance at mediation is, these days a lot of mediators are doing remote mediations on Zoom. So, everybody just logs in and they're in their separate offices wherever. And I've had success with those. I think they work in some instances, but a lot of cases, it really helps to do it in person, because everybody is taking time out of their day. They're showing up at a mediator's office, they're there, and that can help get the case settled. So it's something to keep in mind when you're scheduling a mediation.
Yeah, yeah.
And we talked about this a little bit before, but the caucuses, and this is the time when the mediator is kind of coming in to your room and talking to you about what's going on in the case, and can ask detailed questions, can kind of figure out what the hot button points are, the strengths and weaknesses. Do you have anything you want to add on the caucuses, Bob?
Yeah, so caucuses are where the real work is done. So it is important to focus a bit on them. A caucus really is all the plaintiff people are in one room, all the defendant people are in another room. Sometimes you have multiple parties to a case with different lawyers, and they may be in one room if they're co-plaintiffs and then separate into other rooms in that. But I like at the beginning, my first visit to a room, to find out, to establish a relationship with the client principally. and ask them get questions that are getting to know them, getting to know if it's an injury case, is it debilitating? What are the problems? Something about the accident or the contract, and just get their input. Everything that is said is totally confidential and private. I share nothing with the other side unless it's cleared. I'd like to ask the lawyer uh, in each of the caucus rooms at the first visit. So what seems to be holding up settlement here? We've already learned in the joint session what the last offer was and what the last demand was. I'll ask those questions. Um, but sometimes you find out there's a thing, you know. Sometimes I found that out in my individual calls to the lawyers before we begin the whole mediation. But and then when I revisit people, it's narrowing in on issues, talking about the risk of this or the risk of that, how likely it is they'll prevail on that defense, things of that nature. And hopefully, with a few visits, bringing new offers or new demands revised to
Yeah,
the.
and it's great to have mediators like Bob that has been a practicing attorney for decades. And a lot of times when you're representing clients in mediation, this may be the first lawsuit or dispute that they've ever been involved in. And they don't know, what is going to happen if this goes to court, how long is it going to take, how much is it going to cost me? And Bob, can do a really good job explaining that to people that, I've seen these types of disputes, I've handled these, I've taken these through trial, here's what can happen. So it's important for parties to hear that because, getting your client's head into a space where they know that it makes sense to settle is very important because, like we said earlier, the risks and costs of going to trial can be substantial.
I actually I say it because it's my strength. But I'm still saying it. I think it's really important if you're trusting a mediator to be really helpful, to have a mediator who has sat waiting for verdicts for both plaintiffs and defendants on these kinds of cases. Um, Nothing like having done that to let you realize what really can happen
Mhm.
on cases. So
This next slide just kind of talks about, offers and demands and how to, approach those. And in mediation, both parties are there in good faith, trying to be meaningful and get this settled. So it doesn't help. And, this is kind of the lawyer and the mediator's job is to get the client to understand that lowball offers and crazy high demands aren't going to help get the case settled. So if your client, walks in and, they know they owe some money and they say, I'll pay them, $5 and that's it. I'm not moving. That's not helpful. That's not going to get the case resolved. Same thing on the other side. I want $100 million or I'm leaving. You have to be realistic. And the mediator can help the parties understand what that means, and especially someone like Bob that's taken these cases through trial, and people that think, oh, I have a $10 million case. It's like, well, if this goes to trial, based on dozens of other cases that I've handled that are just like this, I don't see that happening. So they have to be realistic. They have to figure out what their needs are. Like, in a mediation context, if you resolve the case, you can put things in a settlement agreement that a court might not be able to give you if you fight in the lawsuit. I want as part of the settlement agreement that my neighbor, agrees to turn off their backyard light every night at 9 o'clock. You might be able to agree to that and they'll sign it. But
right.
if you're in court, a judge might not have the authority to order that.
Right.
So what are your needs? How can you work that into mediation? And then Bob, do you want to talk about the mediator's proposal and how that works?
Sure, I do. And could I also add, lowball offers and crazy high demands. A lowball offer um, and a crazy high demand, it's nothing. The lawyer's job is to come up with a realistic demand, but frequently they don't, because there was a bunch of really good reasons and then a bunch of other reasons, but they don't. Maybe they really haven't come to grips with what their client is expecting from them and all that. But as I say to plaintiffs, usually when there's a low ball offer, I've never been. They say I'm insulted. I'm buffet. Don't ever be insulted when people are offering you money. I mean, it's money. It's still money. You know, they're in the ballpark, so to speak. They're beginning the process, and I that's the first goal of the first caucus, to change the demands from not being a realistic demand to something that the other side can deal with, and vice versa. Um, Mediator proposals uh, are thought of frequently as a last resort, and they're a thing. Um, I kind of think I'm more in the camp of people are asking your opinion and views about things. They kind of evolve, as far as I'm concerned, through the course of a mediation. Um, I begin to find myself urging people in a direction without saying you should do this, you should do that, and I don't say that. But if there is an impasse and it looks like people are not interested in moving, I'll ask both sides individually. Would you be interested in a mediator proposal? Uh, I have a view of the case. I'll only say it if you agree and if the other side agrees that I provide a proposal. And I'm very happy to do that. Um, I'll only share anything about it, other than the fact that I've provided the same proposal, if both sides agree to it, or it does something significant in the case. Frequently does. Um, and by the way, day one of a mediation, at the beginning of a case, doesn't mean if it doesn't settle, it's over. Over the next couple of weeks, people really do keep talking, and a mediator's proposal can keep it going. And they may agree they need some discovery of some sort, clear, and may resume. But it's a great process. Trust the process.
So closing out a mediation, let's say that you're at mediation and you actually reach a settlement with the other side. One of the things that I do as a matter of practice is I always go into a mediation with a draft settlement agreement prepared. And, some of the blanks aren't filled in, but the meat of the agreement is there. And if we do come to an agreement, I like to get that finalized and signed before anybody goes home. We don't want to get to a handshake deal,
Right.
and then everybody goes home and sleeps on it and they change their mind the next day, and then you're back to square one. So if you do settle, either have a settlement agreement ready, or sometimes if you don't, the mediator can help put together like a memorandum of understanding, something with some bullet points that the parties sign. I've been in a situation where we negotiated a resolution and there was nothing signed, and the other side backed out after a couple days, and it was a big problem. So it's very important to get something signed. And then on the flip side, if nothing is agreed to, then the parties just leave, and that's the end of the day of mediation. Sometimes parties won't come to an agreement that day, but a couple days later, settlement is still fresh in their heads and they're thinking about it, and they enter into an agreement 2 days later. Or like Bob mentioned, sometimes you'll have multiple mediations. Like, you have a mediation with Bob, you get close, but it's not quite there. You maybe do a deposition or two of some important people, and then you come back, a month later,
Mm.
for day 2 of mediation, and it gets resolved. So, you know, there, like we said at the beginning, it's voluntary, but it's a very, very valuable process, and it doesn't always work on the first day, but it can work if the parties, you know, keep focused on settlement. Anything else you can think of about kind of, you know, getting
No,
a
I really agree. It's really important to nail it down on paper at the mediation before everybody leaves. I bring a very bland, but with all the important elements, release form with me. Sometimes cases have to be, resolutions have to be approved by somebody else. If there's anything else out there and there's not a signed memorandum, it's kind of a good idea to have a tentative follow-up date where it makes it less escapable if you have to come back to sign a document. And and then it's resolved paperwork wise in the interim. You get the approval of whoever was needed. Could be a lien on a case. Somebody at the lien outfit needed, in personal injury cases, medical liens, Blue Cross Blue Shield, not to pick on them as an example, may have a lien. Somebody has to approve it. Workers' comp is normally a big one, but you want the workers' comp person there at the mediation. So, yeah, nail it down on paper or do something positive like creating a follow-up date. And be realistic, rational, reasonable, as the lawyer.
Yep. And so a few tips to kind of just have a successful mediation is, stay skeptical, keep your own counsel, understand them, listen to them. It's okay to vent. If the client needs to vent, let them vent. It's a good, safe environment for them to do that.
Before you mention some other stuff, there's a thing that goes on with a mediation that is really, I think, important to understand, which is why the joint session is important. In, for example, an automobile accident where somebody's badly hurt, they've been suffering in, pain, and they think the other side is ignoring their problem, but they want their day in court. And I just have to say, when I was a young lawyer, I'm like 35 years old, and I'm 30 years old, and I'm trying a jury case, and there's a woman who was injured in an accident on the witness stand. And she finishes her direct testimony. And the lawyer, I'll remember Marty for the rest of my life. He was like 48 years old. He's clearly my senior, very well respected. He had nothing to fear from my next cross-examination, or she didn't either, So, but the judge, it's 11 o'clock. He took the Massachusetts, the 11 o'clock morning break for me to then cross-examine the lady. He comes over to me during the break. He says, "Bob, case is settled." And I said, "What?" I thought somebody negotiated from the company behind my back. And he said, "No, she took the last offer. She was a great witness." He said she just had to tell a jury what had happened to her. She wasn't afraid of me. He wasn't, that's for sure. But people have a need to get things off their chest. And I think that's what mediation can provide in some circumstances. And venting, as long as it's not out of control, is important.
Yeah. And then, respect, obviously.
Yep.
Treating everyone with respect is only going to help to get the case settled. If people are being disrespectful, rude, it's not going to move the ball forward. And then do you want to explain the everyone has prejudice in the mediation?
Oh yeah, because the mediator has a prejudice too, huh? The mediator does. Everybody has a prejudice. So here's a conflict between a plaintiff's attorney and a plaintiff, for example. Some of them, the attorneys, I knew several who really they wanted to go try the case for multiple reasons, whatever the case is. They always wanted to go try it. And that can be good because you can be helpful. But if your goal is to try the case rather than to fully compensate a needy client, there's a little inherent conflict there. So everybody there has to be aware. The same's true on the defense side. The lawyer wants to be the hero, doesn't want to come off, even though the case should settle, and doesn't. That's why they want a mediator, give bad news to the other sides, and they want to hear it that way. But so be a little skeptical, everybody. But even the mediator has some prejudice, and I'm always prejudiced in favor of resolving that dispute. Although everything is above board, straightforward, and you're always going to get from almost every mediator there is straight information. So, but there's always a thing going on in the background.
Mhm.
Which I like to watch.
This last slide is just some Q&As on mediation that we can try to answer. But the typical costs of a mediation, mediators usually charge by the full day or a half day.
Right.
And you're gonna pay, a flat rate. It depends on the mediator and the time that you need to do it. But usually the parties split the cost. So let's say the mediator's fee for a full day is $4,000. Then
Right.
each side would pay $2,000 for the mediator.
Right.
Then there's also the cost if, the parties are represented by their own attorneys, they would be, paying for their attorney to be there. There's really no other costs associated with mediation. Like there's no court fees or anything like that. It's a private, out of court process. What to look for in a good mediator? Well, as somebody who uses mediators all the time, I would say that obviously you want someone that has experience, that if you've used them before, you'll know like what their temperament is and how well they've
Right.
done.
Right.
So you can ask around other attorneys if they've used some mediators that they can recommend. But one of the key things too is like you want somebody that has experience in the type of dispute that you're mediating. So if it's a real estate dispute, you want to find a mediator that is good at handling real estate disputes. Whereas if it's an employment issue, you want to find a mediator that handles employment mediations. Anything else that you can think of, Bob?
As I mentioned, I think it's really important to have a mediator who's experienced on both sides of the versus sign, and a mediator who is experienced by having actually prepared, tried cases, taken jury verdicts on both sides of the versus, and resolved disputes, and is experienced in mediating and getting people. Other than that, there are definitely, I remember there's a judge, a retired judge in Boston, who's at the beginning of the mediation world, so aggressive. He was, but he was successful. People, he used to give out golf balls with his face on the golf ball and say, "Don't get angry with each other. Hit me on the course tomorrow."
Yeah.
But others, I think it's really important to have mediators who listen to you and are actively listening. So those are my takes.
Yeah, and then just ways to reduce the costs of a mediation. Like I said, the mediator's fee is a flat fee typically, but the way that a party to the mediation could reduce their costs is, they're going to have an attorney there, and whatever they can do to help prepare the case for mediation. If there's a lot of documents in the case or a long factual history, if the client can, put those in an organized fashion and hand them off to the attorney, it makes it a lot easier and less time consuming for the attorney to go through that stuff, help present the case to the mediator.
Yeah. Can I add one thing too? It's really important to set the tone, going back to the very beginning. Every case should be mediated, and it begins at the beginning. I think it's important for a lawyer to copy the client on everything the lawyer does. It's just my take. But copy, it's important for the lawyer, and a good example is personal injury again. To fill the insurance company's file, not arguing all the time, to fill it. So new medical records, new bills, and all that, and begin the process of talking about how when we finish treatment, we'd be glad to give you a number, and then talk about mediation, your willingness to go to mediation. It used to be people thought they were caving in, they weren't trying, they weren't doing. It's just dispute resolution. And what people miss, this is, I like to tell people, you can mediate your case here, or a jury can mediate it, because every jury has 12 people. You've got 2 or 3 on each side, one pro plaintiff, one pro defendant. They like this one more, and it's the people in the middle who are going to be give and take. Well, damages a little here and liability a little there, and compare. It's not they're mediating. So either the parties mediate it or somebody else mediates it and takes it out of their hands. So
Yeah, and at a mediation, the parties have control of their destiny, whereas with a jury, the parties do not have control. They're going to let somebody else make that decision for them,
right,
and they may not like it.
right,
So,
right.
well, thank you for listening and watching, people. And like I said, I'm Steve Blake. This is Bob Flynn. Here's our contact information if you'd like to get a hold of us. And we appreciate your time. So thank you very much.
Yeah, and it's been a pleasure. Enjoyed your company again, Steve.
Okay, well, take care, Bob, and we'll see you soon. Thanks, everyone.